Hi, and welcome to Beasley Bowman Lawyers. Today, we are going to look at drink driving offences in New South Wales.
Hi, and welcome to Beasley Bowman Lawyers. My name's Josh Bowman. I'm the traffic lawyer and criminal lawyer here at our firm. Today, I want to have a chat to you about a recent matter that I appeared on at Burwood Local Court. This is quite a serious traffic matter because it involved 3 major traffic offences all within the space of one night. Those charges include middle range drink driving or middle range PCA, another charge of driving under the influence of intoxicating liquor, and also a third offence of driving whilst on a suspended driver's licence. Basically, the circumstances surrounding this matter were that my client had just returned from overseas. His girlfriend had broken up with him whilst he was overseas. His friends decided to take him out to dinner. He'd driven to the restaurant. He'd only planned to have 1 or 2 drinks over the course of dinner. However, throughout the night, he was informed by his close friends that his girlfriend had been cheating on him for quite some time. And what this did is it triggered off quite an unusual emotional event for my client, where he decided to drink alcohol far in excess of what he usually would, or what he actually had planned to do that night. So he consumed a large amount of drinks, including some drinks of very strong alcohol-based spirit drinks, and he then decided to sleep in his car for a period of time after everyone had dispersed and left the restaurant. His friends were concerned about him. They said, "Oh, you can't drive, you've had far too much to drink," but he assured them that he was going to sleep in his car and then wake up the next day and drive home, which could have been problematic in itself. However, my client, he returned to his car. It was quite late at night. It was about 1 a.m. in the morning. He slept from about 1 a.m. till 2:33 a.m., so about 2 hours in the car. He was having trouble sleeping. He was still emotionally upset at the devastating news that had been broken to him throughout the night. And he made a very foolish and silly decision of turning his car on and thinking he could drive home, despite the fact it was in the very early hours of the morning and there not being much traffic around. But unfortunately, as he was only 1 or 2 kilometres away from his home, he lost control of his vehicle and he crashed into a concrete barricade or barrier. Police ended up arriving on the scene. They breath tested him. They found that he did return a positive blood alcohol reading. They took him back to the police station and he delivered a breath analysis at the Ryde police station, a blood alcohol reading of 0.139. So he was well into the middle range category and not far off the high range category, which is at 0.150. So he was well intoxicated, and as he was charged, the police also issued my client with a notice of suspension, which meant that because his reading was into the mid-range category, he was unable, or the police suspended his driver's licence until such time that a court had dealt with his matter. So he was put on notice that he could not drive his vehicle. He was obviously still very intoxicated, still very emotional and upset. He left the police station and made an absolutely further stupid and silly decision to walk back to his vehicle, get into his car and attempt to drive that vehicle home. And he did make the vehicle home. He drove home despite the minor amount of damage that was sustained to his vehicle from the prior accident. He got home. Police had then later that morning patrolled the area, not long after he'd been released from the police station, seen that his vehicle was gone. They drove home and they actually caught him in the act of getting out of the vehicle as he had just driven his car into his garage. So basically, out of going back to his car after already being charged with the middle range PCA offence, he was then breaking 2 further laws and committing 2 further offences. One, he knew that he was on a suspended driver's licence, so he was then further charged with suspended driving. And 2, the third charge was a drive whilst under the influence of intoxicating liquor, or otherwise known as DUI. The reason why this particular charge was put in place and not a further offence of low, middle, or high range PCA with a particular blood alcohol reading was the fact that police are not allowed to charge you with a PCA offence with a particular blood alcohol reading if you are at your home of residence. They're not allowed to breath test you at your home of residence, but they can issue you with an alternative offence of drive under the influence, which is DUI, and that's exactly what they did. So out of this incident, my client has incurred 3 major traffic offences. The middle range PCA from the first incident and offence. After he was released, he then drove his car whilst on a suspended driver's licence. That was the second offence. And the third offence was the drive under the influence of alcohol, which was the DUI. So it was a very, very serious situation. It was an absolute horror night for my client. And it was, he was just thankful after having, especially after coming to and further going and doing the traffic offenders program, he was extremely thankful that no one was hurt or injured or even worse, anything worse came out of this incident. He did go do the traffic offenders program. He took a lot away from that program, and he wrote a letter of apology to the court explaining really what did go wrong on that night and how it was very much out of his character. He showed the court what significant lessons that he took away from the traffic offenders program. He did also explain to the court that since being off the road and having to catch public transport, it's a constant reminder of the very dangerous situation that he put himself and others in, now that he has a lot of time to reflect on his actions whilst he's catching public transport on a daily basis. So basically what we did press to the court was the fact that my client did have a strong traffic history. This appeared to be very much out of his normal character. And further to add to that submission was the fact that he had been dealt with some quite emotional and upsetting news, which clouded his judgment on the night of the incident. In relation to the penalties that were handed down by the court at Burwood, for the middle range PCA offence, he received a 12 months disqualification, which is an automatic period. He wasn't dealt any leniency in the disqualification period due to the situation, the aggravating features surrounding the accident and the further offences. So he received the standard 12 months disqualification. That was to be backdated from the date of the traffic or when the offence occurred. In relation to the drive under the influence, he also received a 12-month disqualification, but he also received a 2-year good behaviour bond under Section 9, which means that if he breaks the law again whilst on that good behaviour bond, he can be brought back before the court and resentenced on this current offence. For those 2 offences relating to alcohol, he was issued a combined fine of $1,500 or $750 per offence. And then in relation to the suspended driving offence, any suspended driving offence of a first offence or a first offence within the last 5 years will incur a mandatory disqualification period of 12 months. So that was another 12 months disqualification. He also received a further $1,000 fine and a further good behaviour bond for that offence. Now, if we add all these penalties up, it looks very ugly. He's basically incurred 12 months disqualification for each of the 3 offences, fines and good behaviour bonds. But if we have a look at the way the disqualification period falls, I was able to request that the magistrate make an order under the legislation that these disqualification periods were run concurrently. And when I mean concurrently, run at the same time as each other, not cumulatively. So it wasn't as though he received 3 years disqualification off the road. Instead, he would receive a 12-month disqualification from the date of court, which is when the suspended driving offence started, and the other 12-month penalties would run at the same time. So at the end of the 12 months, he would be eligible to get back on the road and apply for a new licence. So ultimately, given the disastrous situation, the seriousness that my client was in, the seriousness of the situation that he was in, the fact that he had 3 major traffic offences all arising out of the one incident, This was a very, very serious situation my client was in. He could have received a lot worse a penalty, but we did prepare a good case. We really pulled at the heartstrings of the magistrate and showed that this was a very unusual and exceptional event, very much out of our client's usual character, taking a look at his traffic record and the way that the incident had come about, given the very emotional and upsetting news that he had received, which had clouded his judgment on the night of the offence. All in all, our client was extremely happy with the result. He was obviously expecting to be off the road for a lot longer than he was, but we were able to ensure that his disqualification period was run on a concurrent basis and that he was eligible to get his licence back within 12 months from the court date. So guys, this is a very tricky type of matter that we had to deal with. When I say tricky, it wasn't your standard drink driving offence pulled over with a random breath test. It involved a number of high-range traffic offences. There was a number of issues to consider, and submissions had to be carefully prepared and presented to the court. So if you found yourself in any sort of situation where you've been charged with an alcohol traffic offence, or any sort of criminal matter for that matter, we do a lot of this sort of work at all the local courts in and around Sydney. And please feel free if you want to give me a call. My name's Josh Borman. Happy to have a first free telephone consult with you on the phone. You can call me on 02 9283 8622, or you can visit our website at Beasley Borman. There's different sections there that you can choose relating to criminal law or traffic law or any other sorts of law that you may need to make yourself aware of. But if it's a drink driving matter, go along to the traffic law section. There's plenty of information on the laws, penalties, offences, videos and blog posts that we've put up. You can certainly make yourself fully aware of the potential situation that you're in. But if you want to give me a call, I'm happy to give you a bit more of an idea about your situation and possibly discuss any legal representation that we can offer you in your particular case. Thanks for tuning in, guys.